to the Elder Law Out Loud podcast. I'm Carla Ray. I'm a business development manager at Family First Firm, Florida's largest elder law firm, here with our founder and leader, Jeff Hotzen, lead attorney here at the firm. And today we're talking all things estate planning essentials. And Jeff, I think when people hear estate planning, they assume that that's something that I need to worry about later in life.
Agreed. That's a joke I oftentimes make is that people assume that they have until they're 120 to get their documents together, because they're not going to die until they're 121. But then, of course, life happens, 70, 80 strokes and things like that. And, unfortunately, their families are left picking up the pieces because they didn't do any planning.
Okay. And I like to tell our clients that estate planning is for everyone.
Mm-hmm.
Anyone over the age of 18 really
That's
should
right.
have some sort of plan in place. So it's not just wills and trusts.
Right.
What are you doing to prepare your estate through the legal process?
Yeah. Like I oftentimes talk about, I said that there's really two pieces to this. There's taking care of you while you're alive, should something happen to you. Maybe you end up with Alzheimer's, you end up in a car accident or have a medical event and you can't make decisions for yourself. And then the other piece of it is your stuff after you pass away. What happens to that? Now, if you are younger and you have minor children, there's also a third piece, which is what happens to your minor kids should something happen to, say, you and your spouse or, you and your child's other parent. So, there are really kind of, I'd say, two, normally sometimes three very distinct areas where the types of estate planning we do really account for everything that you might care about as you age or as things happen in life.
Okay. So for somebody just starting to think about something like this, what's the first step that they need to take to get their affairs in order, so to speak?
Sure. So, realistically, it sounds self-serving, but truly, you want to talk to an attorney about this stuff.
In Florida, you can call us here at Family First Firm.
That's right. I would say, though, that, in general, maybe listening to something like this might actually give them a lot of things to think about so that when they do go talk to an attorney, they are going to have, I think, a little bit of a better foundation for questions to ask and things to consider. I will tell you there are some lawyers who do this stuff and they do not, I'll say, take the same level of specificity to it that some firms may. And it can be very cookie cutter in certain places. And I think, you don't know that unless you know what questions to ask. So that's why I think something like this actually may be very helpful for somebody just to make sure they have a foundation. So when they go meet with an attorney, they know how to make sure that their estate plan is actually doing what they want it to do.
Okay. So I will be admitting something that hopefully doesn't get me in hot water with the boss here, but I don't have any estate planning in place.
You and most people.
Yeah. So
you're in good company.
I'm here at the firm. I talk about this all day long with our clients and our coworkers, but I don't have any of my documents in place. I have a 3-year-old son. So everybody keeps saying you need to get a will set up. You need to set some advanced directives. What does that mean? Pretend I know nothing.
Sure.
Explain it to me like I'm 5.
Absolutely. So let's start with your son. Right. I mean, I think, for those of us who have minor children, they're kind of our priority. Mm-hmm. So let's start there. Should something happen to you and your son's father, let's say you guys are out on a date night and your son's with a babysitter and you guys are on I-4 and it's a crazy road and you end up not coming home. Not hoping that for you, but, worst case scenario. What generally would happen then is the babysitter eventually, when she's not able to get a hold of you and it's 3 or 4 in the morning, she's like, oh my goodness, I don't know what to do. If she doesn't have anyone else's number, she's probably going to end up calling the police. The police are going to come over, or God forbid, they're going to figure out that they need to show up at your house because they've been able to run the tags and whatnot. From that point, they're going to be looking to find someone local, a local relative or something like that to be able to watch your son. But while they're figuring that out, they're very likely going to get like a foster family involved. So kind of the worst possible scenario, your son has just lost both of his parents and now he's being put with strangers in a strange environment that he's not familiar with while they try to find, either one of your parents or his parents or something like that. So, not exactly what any of us would want for our children. Additionally, then they're going to go to court to figure out who's going to be the person who would raise your son. So, it maybe your parents want to raise your son, but his father's parents want to raise your son, and so now all of a sudden they're fighting about this, or maybe you have a sibling who's coming and saying, well, no, I think I should be the person, and so it can get pretty ugly. The nice thing about the plans that we put together, it accounts for all this. Not only does it name the person who would raise your son, so you tell the courts who you would actually want to be the person to be the permanent caregiver of your son until he's 18, but in addition, we also put together things to make sure that on a temporary basis, that your babysitter would have know who to call. You'd be giving local people, friends and family members numbers. We would be naming legally temporary guardians who could take care of your son in that short term while they're getting in front of a judge to be able to name that permanent guardian. Sometimes that permanent guardian is going to be out of the state, and so you want someone temporarily here in state to be able to, take care of your son until those people are able to come in and be approved as the guardian. So that's the first step. Now, when it comes to the second piece, which is you. I always like to say, I think we're more important than our stuff. If you had the option, to either die or give up your stuff, most of us would give up our stuff, right? So I think it's clear to say that we're more important than our things. We can always earn more, at least until you get much later in life. So that's where it comes to things called advanced directives. And these are legal documents that name financial, legal, medical decision makers for you if you're unable to do those things yourself. So very common names for these documents are powers of attorney. A lot of people have heard those names before. They may not be as familiar with what they are. Basically, a power of attorney gives somebody else the ability to make a legal or financial decision on your behalf. So this could be anything from paying a bill, filing a lawsuit against somebody who maybe hurt you in a car accident, for instance. It could be even things like accessing retirement accounts to be able to liquidate funds to pay off mortgages and things like that. Then you get over to the medical side. In a lot of states, they call it a medical power of attorney. Here in Florida, it's normally referred to as a designation of healthcare surrogate. It's pretty much the same concept, but different states have different naming conventions for different things. So that's what you'd be looking at. Here in Florida, the healthcare surrogate would make medical decisions for you if you couldn't make them yourself. So I've been talking for a while. I'm going to stop for a second,
Sure.
give you a chance to process that and ask any questions.
Okay, yeah. Because I think people assume that estate planning is only when you're nearing the end of life, and it's not at the beginning of a new chapter in your life, where in this case, particularly with young children, that is something that you need to be thinking about. I'm well under the age of retirement or accumulating a lot of assets in my life, so I may not think that I actually need to set up estate planning in terms of a will or a trust, but definitely getting documents in place for my son. That seems like something any parent should do.
Absolutely. And there is another piece of this though that is tied to your son, which is the final piece, that third piece, which is your stuff. So we agreed that your son and you're more important than your stuff. But if you don't have a plan in place for how your things are going to go to your son, they're going to be held in a, so let's say something happens to you and your husband and you guys both pass away and you leave whatever you leave behind for him. Maybe there's life insurance, retirement accounts, savings, checking, a house, whatever. All of that stuff then is going to be held in a guardianship for your son. When he turns 18, he gets everything. Now, I know you've been 18 a little bit more recently than I have.
Not
but,
that recently.
Well, it's been more recent.
I think we're peers. I think we're peers.
Regardless, the point is that I remember being 18 and I would have made terrible decisions if I had gotten a bunch of money when I was 18.
Even the student loans I took out, I
Yeah.
used one to go to Cancun. Yeah. Which is why I don't need a lot of estate planning right now. I have a lot of assets.
But I mean, so the point is, I think oftentimes we'd like to potentially save our children from themselves. And if you were to do estate planning, you could structure your son's inheritance so he doesn't get everything at 18. And maybe it's held in a trust for his benefit, and it can be used for him in paying for college and helping, pay for his, maybe his dormitory if he has an apartment off campus, and books, and a stipend for food and gas and things like that. But instead of just, hey, here's everything all at once, it's like, here, let's stretch it out over a period of time. And you can get very creative with that. We've had people say, hey, I want to held in trust for my kids and then their kids and then their kids and so on. We've had people say, hey, I want it, held in trust until they're 50 and then they get everything. Those feel a little onerous to me. The reason being is, that I feel like most people need the money, if you will, earlier in life. when we're 50s, 60s, 70s, well, you may not really have that much of a need for money because you've already built that financial security in your life. So I think that delaying it that long can be a problem. The flip side of that is, I don't think you want to give it to them at 18. I can tell you what I've done for my daughters is we've said at 25, 30, and 35, basically those are the milestones where our children get a percentage of what's in there, the last distribution being at 35. And so it can be used for them along the way, helping maybe pay for a wedding, help them start a business, a down payment on a house, purchasing a car. But it's those milestones where then they get more of it, and instead of the trustee using it for them, they actually get the money and they got to figure it out. The good thing though is because we split it out over, 3 milestones over a 10-year period, hopefully if they screw it up the first time, they learn their lessons and maybe they don't mess it up the second or third time.
You get a couple tries at it.
Yeah, a
Third
couple
time's
bites
a
at the
charm.
apple. Yeah, exactly.
No, you're talking about a trust here. For folks who are maybe moving to Florida from other states, I feel like we get a lot of clients in who say, well, I've already done a will where I'm from, and wills are held to a little bit higher standard based on whatever state you live in terms of whether it's probatable. So probate, the process that occurs after someone passes to settle the estate. A trust is the only way in Florida, at least, to completely bypass that process.
It's the only way to really insure it. In theory, there are a few ways that you can avoid probate. The first is just to die with nothing. Doesn't sound very fun, but it works.
A little grim.
Yeah, exactly.
We hope none of our listeners are in
That's
that
right.
scenario.
That's right. But I mean, that sometimes people say, oh, I don't, my dad passed away. He had been in a nursing home for the last 8 years of his life, spent on everything. He didn't have anything left. Do I need to go through probate? And I tell him, well, does he have anything? They're like, no, everything went to the nursing. I'm like, well, then no, he doesn't. There's no reason to go through probate and spend money with an attorney. If everything is jointly titled, so oftentimes you'll see this with married spouses. Like, I'm assuming, like I can tell you from my perspective, my wife and I have a lot of jointly titled assets. So both of our names are on them. Now, I will also point out that our trust is the beneficiary of this, but let's pretend that it wasn't. What that would mean is that if I were to pass away, and statistically men were going to pass away first, it's just, according to the actuary tables, we burn out quicker. So, and I'm a few years older than her, so I'm going to assume that I'll die first. But assuming I die first, then, basically everything that's jointly titled automatically goes to her by what's called operation of law. Now, that's all well and good when you have a spouse. It's not so good if you have maybe a second marriage spouse and you have children you want to protect from a previous relationship. It's not as good when you have multiple children and you've named one child you're jointly titled with one child and the other three now are hopefully relying on that one child to do the right thing and split their inheritance with them. There's a lot of ways where that doesn't work, but that is a way that can also avoid probate. But yeah, I mean, I will tell you, wills do not avoid probate. A will is your ticket to probate. That is the number one misconception about what we do here. Out of all of our practice areas, Medicaid and everything else, people come in, they say, hey, I want a will because I want to avoid probate. And I tell them a will is nothing more than a set of instructions to a probate judge, which means it is your ticket to probate. So if you want to avoid that, the only real sure way to do it is using a trust.
At least in Florida. There are some states where it has a higher regard.
No.
Right? No.
No.
Okay.
So no matter what state you're in, a will is instructions to a probate judge. Now, there are some states where you can do an administration without what they call traditional probate. Those are subject to monetary thresholds. So like it can't be more. I can tell you that we have it is still probate. It is an abbreviated version of that here in Florida. It's called summary administration, and you have to have less than $75,000 of assets in order to go that route. So I know that there are some other states that have, I think, even more abbreviated or shorter versions of this, but they are subject to some asset thresholds.
Okay. We get that question a lot from our clients coming in, especially those who have moved from other states, particularly northern states. They think that if they have the will and it's on file somewhere, that it's ironclad.
Yeah.
You're here to say that that is not necessarily the case.
So the will can be ironclad, if you will, that in the sense that it's still going to be valid. but it's just not going to avoid probate.
Gotcha.
Is the concern.
So for people who don't know and they see trust as just this abstract thought, what is a trust and how does it complement a will?
Sure. So I'm going to lay a little bit of foundation, which is why probate is needed in the first place. Probate is needed if you have assets in your own name and they do not have anyone else's name on them and you pass away. The only way for them to go from you to the people they're supposed to go to, and oftentimes our children, is through this probate process. Now, the way a trust works is and it's kind of an esoteric sort of idea, and so I'll try to make it as easy to understand as possible. But it's like a container, if you will, a legal container, almost like a legal wrapper you put around your stuff. The example I sometimes use is it's like for women, it's like a purse. You own your purse, you control your purse. Everything inside your purse is yours, right? You take whatever you want out, you put whatever you want in. And that's the way a trust works. Now, the difference is that instead of it being a purse, it's a legal structure that then has legal title to your assets. Now, you, of course, are the person owning that trust. You manage it, you take stuff out, you put stuff in. Nobody can stop you from accessing what's in there. But when you pass away, because everything that you own is owned by this wrapper, like I said, this like legal wrapper, it doesn't have to go through probate because the trust itself continues to exist after you pass away. And it says, hey, once you pass away, here's who's entitled to take control. That we call it a successor trustee, but that's the person who takes over. You can think of it like an executor. They take over, and then they use those trust assets in the way that you tell them to use them. So very often, I could give an example here, and I'll use my personal trust as an example. I've said, hey, my father is going to be the trustee of my trust when I pass away, when both Caitlin and I pass away. And so when we pass and he takes over, he's going to use those funds for my children. But it's going to be, we've given him a lot of clear direction in the trust document saying, okay, you're going to use it for education. You're going to use it for, I say you could purchase a car. Well, that's like a Honda, not a Maserati, right? So there's like limits on what that looks like. If they're buying a house, down payment on a modest place, not some $5 million mansion or anything like that. They're not blowing through this. So he has discretion to be able to decide how some of these things look and what he will use the money for. But then there are those milestones where they get a lump sum of money and he's directed to give it to them with a few caveats in there, which is if one of my children is involved in a self-destructive manner with drugs or alcohol or gambling, he doesn't have to give them any of that money until they've cleaned up their act. If one of them has substantial I'll say, credit card debt or something like that could be used to go after the inheritance, he can withhold it until those are resolved. So again, it's an opportunity to really protect our children from themselves, with the money that's coming.
And what if that person that you assign isn't able to carry out the duties?
That's a great question. My dad is older than me. In theory, he should pass away before me, right? Just statistically, that makes sense. I've named backups. And that's what we generally recommend with everything, whether you're talking about a power of attorney or an executor of your will or this trustee for your trust. You should have backups named. We generally like at least 2 backups. Some people can't come up with more than that, and that's fine. But, we try to come up with as many backups as we can so that unfortunately, most people, once they get this done, they put it on their shelf, forget they ever did it, have it check marked off, and they never update it based on what happens with their life. Well, our goal is to make sure that, if, in my example, I named my father, but if my father passes away and can't do it, we've named some other people as backups who could then step in to do that. And that's my recommendation to everybody is have as many backups as you can. Just account for, nobody knows what life holds for us.
Who is the person who makes sure your dad or whoever is next in line actually does what they're supposed to do?
It's a good question. So there's no trust police. I always say that when we talk about trust, there's 2 types. There's we call it the capital T trust, which is the types of trust we set up. And then there's the lowercase t, which is like, do you trust this person? And if you don't trust that person, you probably shouldn't name them as any meaningful decision maker for you. You can name co-trustees if you want, so that you have 2 people working together. That comes with its own set of challenges, which is if they don't agree, then they're both hiring lawyers and fighting about it in front of a judge. Not what you want for most people. But if an example where that may make sense, maybe if you have a blended family and they each have children from a previous relationship and they're worried that one side of the family might get squirrely or do something, inappropriate, name a child from each side so that there's checks and balances so that, there's never any underhanded stuff that could happen because the other person's going to catch it.
Are there professional agencies that you can tap in if you don't have anyone in your life that you trust to carry out your wishes?
For sure. Yeah, banks and financial institutions oftentimes serve in those roles. As you might guess, it's not for free and it's not necessarily cheap, but it depends on the level of assets you have. You can occasionally find professional guardians and other fiduciaries, sometimes CPAs, who will, and lawyers who will agree to serve in those roles. We actually don't do that here. I always say we do just a few things and we do them very well. And serving as trustee is not one of those things that we do. But we refer out regularly to professionals who will serve in those capacities for people that don't have somebody.
Now, for someone who is listening to this and they're probably panicking because they realize they don't have any of the advanced directives that you talked about, they don't have a set of instructions, meaning the will about what they want to happen to their estate upon their passing, and they don't know the first thing about setting up a trust.
Yeah.
Baby steps here. What is one thing that everyone can do right now to set themselves up a little better for estate planning?
Just by virtue of having listened to this, they're probably already in a better spot. But I mean, there's a whole host of things. I think we have some podcasts, I mean, not some podcasts and webinars out there that we've done that people could watch. I do believe we have some like white papers on this stuff so that, I mean, from an educational perspective, I mean, you can hop on probably just Google and Google lawyer your way into learning more about this stuff. I don't love that option because a lot of this stuff varies by state. And Google generally does not do a good job of giving you state by state sort of information. So there can be some issues with that, but by and large, I mean, there's a plethora of information out there. I mean, I think one of the easiest things is just coming and talk with us. I mean, we do offer free meetings with our clients to be able to help them understand what options are available and help them kind of sort through what might make sense for their family.
Speaking of Google, because I hear this all the time from potential clients. Well, I already did my will. I did it myself online. You can download any number of software, products out there right now to
Yeah.
create your own will. Why isn't that good enough?
So, I always draw the analogy. It's like using WebMD to take care of yourself rather than going to a doctor. You might get it right, but chances are you probably won't. And even if you do, it's really going to hurt. So what I can tell you is that we have been paid far more to fix those things than it ever cost to set them up right in the first place. And the bottom line is, we live in an age of specialization. And most people don't know what they don't know. Everything is becoming more complicated and more complex. And so, that's why I say we do very few things here. We just do those things very well because the days of having generalist attorneys, those are behind us. If you're going to a generalist, you are necessarily not going to get the best legal advice for whatever it is you need because there's no way that somebody who jack of all trades is going to be great at all of them, right? It's not possible. There's too much to learn. There's too much to know. I guess I'll just say that life has become too complicated. So, I say that to then say when we talk about these sorts of things, the average person doesn't know what makes a will valid or invalid. You could sign all those documents, but if you have a blood relative or a beneficiary who happen to be a witness, all of it's invalid. But you won't know that until it's too late. And I mean, very likely you'll never know that. But your loved ones, when they go to deal with it, are going to realize that all that stuff you put together, it was worthless.
And I would be remiss if I did not ask this next question because our two main areas of practice, estate planning and Medicaid planning, when people are thinking about long-term care, some people have asked me, potential clients, is it even worth it to me to set up a trust to do this sort of estate planning if I will end up needing long-term care in the future? Because I think there's this misconception that if you have a trust that has any assets in it, that you won't qualify for those long-term care benefits.
So this is getting a little outside of what I would say is estate planning essentials, but what I would say is that there are types of trust that you can set up that absolutely will allow you to qualify for long-term care benefits, regardless as to what is owned by that trust. So you could have 5 million, 10 million, $100 million in that trust, and you would still be able to qualify for means-tested benefits. Um, that said, well, yes, we know that if you reach the age of 65 years old, there's a 71% chance you're going to use long term care before you pass away. That is a fact. So, almost 3 out of 4 people, when you hit retirement age, you're going to use some long term care before you pass. That's statistically that's accurate. But um, there are a number of ways to pay for long-term care. I think we talked about in the previous episode that you could go back to, where we talk about, there are long-term care insurance policies that would then provide assets for you to use while still allowing you to protect what you have in your trust if you wanted to use a more traditional trust. If you wanted to get a little more, I'll say fancy, with our family fortress as an example, everything in there then would be completely protected, and you could have millions of dollars in that trust and still get eligible for benefits to pay for your long-term care.
And that's a better conversation for a consult with you.
Yeah, that becomes very individual specific. That's what I normally like to say is, with the estate plans that we put together, I think of the last 10 that I've done, they were all significantly different from each other. We don't cookie cutter stuff here. Everything is really designed to achieve the outcome that our clients are looking for. And unfortunately, there are a number of attorneys out there that we see who just kind of use the basic templates and just fill those out and do the same thing over and over, without really any customization or really accounting for the unique situations that their clients are in. So whether it's Medicaid, estate planning, asset protection planning, long-term care planning, whatever, it's really worth a conversation just to make sure that your goals are able to be achieved in the way that you want them to. Or maybe a better way of saying that is letting us show you how we can achieve your goals in the way that you want them to be achieved.
So even though estate planning is for everyone, everyone will have a customized.
Yeah, definitely.
All right, Jeff, thank you so much. And thank you all for tuning in to this episode of the Elder Law Out Loud podcast. If you liked what you heard, share it with someone who you think could use it. You can hit those icons at the bottom of your screen.